Joining us in today's webinar, which is our third series of webinars, Honorable Euphnalis Okubo, Professor Chidi Odinkalu, Dr. Ali Pozi, and Dr. Caroline Nalule. Before we start our today's webinar, in which we will be dissecting the jurisdiction of the East Africa Court of Justice, the jurisdiction to review municipal courts' decisions compliance with the EAC Treaty, we will start by a short prayer. Let me invite Mr. Mogesi to start us off by word of prayer.
Thank you for the opportunity. Let's pray. Our Father out in heaven, we thank you. We glorify your name for this moment as we start this webinar. May it be a success. May we learn and interact well, and may this spur conversations that will enable this regional block and other regional blocks that are also included to flourish, oh God. In Jesus' name I pray and believe. Amen.
Amen. Thank you so much. We will have our East African community anthem before we proceed.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuwajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you for that. Dear attendees, dear panelists, I would like to welcome you to our webinar today. And I would like to remind you that the Kabarak University Press sent out a call for papers, and we are still welcoming any case commentaries and reviews. The deadline shall be 30th of June, 2024. So if you might have any case reviews on East African community law, feel free to publish with us. We also run Usuli blog, where you can publish any material on East African community law. Kindly reach out at our Twitter handle, that is Kabu Press KE. So let me welcome today's panelists. We have His Worship Honorable Euphnalis Okubo. We have Honorable Dr. Ali Pozi is joining us shortly. We have Dr. Caroline Nalule, and we have Professor Chidi Odinkalu. Thank you so much, dear panelists, for joining us. Now, starting as of His Worship Euphnalis Okubo. Honorable Euphnalis Okubo is an immediate former registrar of the East African Court of Justice. He is an arbitrator, mediator, and a regional intervention lawyer of immense experience. He has vast experience working with regional bodies such as IGAD. He holds an LLB, LLM, and MBA from different educational institutions, including the University of Nairobi, Moi University, as well as Uppsala University. Karibu sana, Mheshimiwa.
Thank you, Emily, and thank you all participants from wherever you are in East Africa and beyond East Africa. I think there's somebody who is in Boston, in America. Now, talking about jurisdictional issues and how EACJ jurisdiction issues determine decisions of municipal courts. That issue of jurisdiction reminds me of my administrative law class where we had a lecturer called Sir George Rukwaro, who kept talking about who will watch the watchers. Now, the High Court watches the subordinate courts. The Court of Appeal is watching the High Court. The Supreme Court is watching the Court of Appeal. And then we also have the constitutional courts. Now, to me, EACJ is the one that is watching all the national courts. Of course, the question then still remains, then who is watching EACJ? It is watching others, but who is watching it? Now, this issue of jurisdiction of the EACJ to determine decisions of municipal courts, whether they're in compliance with the treaty or not, has been a matter of discussion for a very long time. But the baseline is this: so long as in those allegations, there are allegations of violations of Article 6D and 7.2, that automatically clothes EACJ with jurisdiction to look at whatever the municipal court did. This is because besides other requirements of being a legal or natural person and respondent being a partner states. So you cannot separate municipal courts from the partner states. All one needs to do is to allege violation of Article 6D and 7.2. That automatically will address EACJ with the jurisdiction to look at what the municipal court did. And EACJ has been doing this for a very long time. There are very many cases that EACJ delved into where they were looking at decisions of municipal courts. I'll just pick three interesting cases. One is Appeal number 1 of 2017, Manirayo Desire. Another one is reference number 6 of 2019, Maleki Wanuka Mabirizi. And of course, the famous one, Mata Karua Civil Appeal number 4 of 2021, or what we nowadays call Karua 1, because there is Karua 2 still pending in EACJ. Now, in Manirayo Desire, the matter arose from a decision of a Supreme Court. That is the Supreme Court of Burundi, where the allegations were that the respondent state, that is the government, through the decision of the Burundi Supreme Court, violated its own laws and therefore violating the treaty. That the Supreme Court, in making its decision, it failed to apply the general principle of law and recognize an affidavit, which was actually to be the primary document in the land transaction. Now, it does not matter whether it's the executive, legislature, or the judicial act or omission that is being complained of. States have international responsibility under the treaty, and if the responsibility is violated by any of its organ, then it's actually inviting EACJ to look into it. Now, Manirayo Desire was decided for different reasons, not for that. It was a question of whether the applicant Manirayo had jurisdiction himself as a person to file a suit or not. And then look at the case of Maleki Wanuka Mabirizi. This is 2019. This case, I've just been wondering, it went the way it went, but had it gone the other way around, maybe things would have been very different. Again, there was a decision of the Court of Appeal, decision of the Supreme Court, and a decision of the Constitutional Court. So Mabirizi went to court to challenge the legality of the Supreme Court's decision in upholding an alleged flawed trial process and a judgment process of the Ugandan Constitutional Court. Look, he's challenging a decision of a Constitutional Court. And he was saying the process and decision of the Constitutional Court and the Supreme Court of Uganda were fraught with illegalities and thus violated Article 6 and 7 of the treaty. The respondent on their preliminary objection was that the court lacked jurisdiction to attend an appeal from the municipal court. Now, that has been an argument by a lot of state councils when it comes to these cases, where they always say these cases are disguising themselves as an appeal. They fail to notice that these cases are actually hinged on the violations of the treaty, but not on the municipal law that was initially being challenged. Of course, that argument that this is an appeal was thrown out by the court because Mabirizi was challenging what? The violation of Article 6 and Article 7 of the treaty. Then there is a Karua 1. This case attracted a lot of attention in Kenya. It attracted a lot of debate in Kenya, maybe because of the personalities that were involved. Karua filed her election petition in the municipal court. She lost in the High Court, went to the Court of Appeal, lost, went to the Supreme Court and lost, and then challenged the decision of the Supreme Court, saying in the process of the municipal courts doing their work, they violated her rights, therefore violated the treaty. All the evidence that were produced, actually, at the end of the day, the court agreed with Martha Karua that yes, whatever happened in the municipal court was a violation of the treaty and they violated her rights. Similarly, in that case, the State Council were arguing that this is an appeal. It's a disguised appeal, which reasoning was dismissed. So there have been many cases where EACJ has been challenging the decisions of the municipal court if they comply with the provisions of the treaty. They may not have gotten our attention so much because of maybe of the personalities that were involved. If you look at the case of Malema Birizi, assuming it went through, at the end of the day, the case was dismissed. But assuming it went through, because he was challenging the constitutional amendment that removed the age limit and the term limit to allow President Museveni to contest. Maybe had it gone through, then it could have even opened up a lot much debate. It's important to note that it doesn't matter what happens in municipal courts. If it violates the treaty, then the EACJ can always kick in if invited so to do. But then, as it does that, what are these powers of review of EACJ when it's reviewing the judgment of the municipal courts? Those powers are actually limited. For example, it cannot overturn the decision of a municipal court. All it can do is say, yes, okay, you made your decision. That is now bridge under the water. However, in your making that decision, you violated the treaty. Remember, this court doesn't have appellate jurisdiction, so it is limited in only making a finding and declaring that the decision of the municipal law violated the treaty. It's not an appeal, and it cannot change the decision of the municipal law. All these decisions, the three I've quoted, you realize they were challenging the highest court's decisions. And as I said, if Mabirizi's case had succeeded, it will have created a much bigger backlash towards the functions and jurisdiction of the court. We saw it in Anyang' Nyong'o's case. You saw what happened, the backlash that came out of the Anyang' Nyong'o case. So I'm imagining if a case like Malema Birizi's case was to go through, definitely the BEP partner states will have reacted to it, and maybe the outcome may not have been pleasant. Possible outcomes will have been to deal with the jurisdiction of the courts. And if you interfere with the jurisdiction of the court right now, in fact, I don't see partner states amending the treaty by every practicing lawyer to look at their municipal courts, what they are doing, and if they are in compliance and in line with all the provisions of the treaty. Maybe facilitators, may I stop here to let my other colleagues also pick it up from there? Thank you.
Thank you so much, His Worship, for your insightful contribution. I would like to invite our next panelist, Ms. Dr. Caroline Nalule. Dr. Caroline Nalule is an international law scholar with specific interests in migration, human rights law, citizenship, refugee studies, and regional integration in Africa. In 2018 to 2021, she was a postdoctoral research fellow at the Refugee Studies Center of Oxford University, working on the European Research Council-funded project Refugees Are Migrants, Refugee Mobility, Recognition, and Rights. She has conducted extensive research on refugee recognition process in Kenya and South Africa and broader refugee matters. One of her active projects being the MIDEC Project Center on Issues of Access to Justice. She holds her PhD in law from the University of Witwatersrand. in South Africa, where her thesis was about migration rights of citizens in East African community. Welcome, Dr. Caroline Nalule.
Thank you very much.
Thank you. Perhaps you can give your opening remarks on this subject, on any area you wish to contribute to.
Okay, thank you very much, Emily, for the introduction. And yeah, I should say that for a long time, my kind of like expertise is still so much on regional integration. For quite a while, I have not been that involved within particularly with the EACJ, but I am kind of like coming back into that, especially now that I'm looking forward to look at issues of what it means East African community citizenship means and how it is being kind of like promoted within the East African community. So I have written, of course, on the interpretation approach of the East African Court of Justice, particularly on regards free movement of persons within the community. And it's there that my interest in the workings and knowledge of the workings of the court and its approach to East African interpretation kind of like got cemented in that. So I want to take up from where Honorable Okubo has kind of like left off. And yes, of course, the jurisdiction of, I think the jurisdiction for the EACJ to determine municipal court decisions, it's written into the treaty, yeah? It's initially, I think that was kind of like the mindset of the framers of the treaty, that the court should be the judicial body and ensure adherence to the treaty in its interpretation and application. That is, of course, in Article 23(1) of the EAC Treaty. But then at the same time, as the treaty has been kind of like amended, in some ways the jurisdiction has become kind of like controversial. At times you see the treaty giving the jurisdiction and at times taking it away. And we can see that with the amendment to Article 27(1) of the treaty, for example, when after that Anyang Nyong'o backlash, when that proviso was added into that article, that the court's jurisdiction to interpret under this paragraph shall not include the application of any such interpretation to jurisdiction conferred by the treaty on organs of partner states. So that is kind of like, it has put the court in a bind, yeah? And it is not only that, there is also another Article 33(1), for example, except where jurisdiction is conferred on the court by this treaty, disputes to which the community is a party shall not on that ground alone be excluded from the jurisdiction of national courts of the partner states. And then also you have the protocols, for example, the Customs Union Protocol and the Common Market Protocol, which in their kind of like dispute settlement provisions, one, the Customs Union Protocols establishes so many committees that seem to oust the jurisdiction of the courts. And then also you have the Common Market Protocol that vests the jurisdiction of the interpretation of violations of the Common Market Protocol into national courts, not really the East African Court of Justice. So we see the kind of like contradictions within East African community law itself. On the one hand, the court is being given the jurisdiction, and it should have that jurisdiction indeed, as it's given its primary role within integration. But then at the same time, you have all these other provisions that seem to take away or kind of like oust the jurisdiction of the East African Court of Justice. And I think also the East African Court of Justice has acknowledged that in some of its cases. For example, the East African Law Society case that was instituted to kind of like challenge those amendments to the treaty. So it's in a kind of a bind, and it's a question of how do we navigate this. And I think here the role really should be with national courts to, in a way, support the East African Community Court of Justice, which from where I stand now, I don't see that much support coming from the national courts. But I think they should kind of like be acknowledging and recognizing that this is the court that has exclusive jurisdiction of interpretation of the EAC Treaty, and we see kind of like more judicial communication between the courts, but we are not seeing that. So that is something I just wanted to mention from what Honorable Okubo said, that yes, it does have jurisdiction, but that jurisdiction is contested, and the very treaty that confers that jurisdiction is in some ways taking away from that jurisdiction. I think I'll stop there for now, and I'll wait for the next question. Thank you.
Thank you so much, Daktari, for your insightful contribution. We are joined by Dr. Ali Pozi, who has just joined us. Karibu sana, Mheshimiwa. Dr. Ali Pozi is the Deputy Permanent Secretary at the Ministry of Works and Transport in the United Republic of Tanzania. He's also an advocate of the High Court of Tanzania and a former lecturer at Albi University and the Law School of Tanzania. His areas of focus include international law, international human rights law, aspects of international courts, and the African human rights system. He holds a Doctor of Laws from the Center of Human Rights at the University of Pretoria. Karibu sana, Daktari. You can give your opening remarks.
Hi, asante to everyone. Can you hear me actually?
Yes, Daktari, you can.
Oh, great.
So
because I had my personal battles to be here. So first of all, I appreciate the organizers for reminding me and getting back to my roots. And I really thank you for that. East African courts, East African community law, and regional integration law is for some time be really part of me. As you rightly say, I'm now at the ministry. Actually, it's called Ministry of Transport. So in a way, I deal with some other things in relation to law. But I think what I'll speak today will be of importance. Why I'm saying this, it is because now I'm not an academia anymore. Not an academia from the Center for Human Rights, University of Pretoria. So I'll be now speaking as a little bit part of the government and how I see things in as far as our court, our Jumuiya is concerned. So I think we are not yet at the discussion, right? So I just give like an opening remark. Is it? I just want to know what is now the house in order. Why jump into the discussion? What is it?
Dr. Just feel free to jump into the discussion.
Okay, I think that is good because of my situation here. So there's a number of issues that I would think for over now, I think over 2 decades, the court has been existing. I think there are some of issues that we should be real, we should be realistic to ourselves. I just heard, for example, the previous speaker referring my good friend, the former registrar of the court, acknowledging that there is an issue of jurisdiction. This is where I want to start now. I think the issue of jurisdiction of the court is still debatable, whether we like it or not. I used to write a number of articles saying we can deal with human rights, we can deal with rule of law, we can deal with good governance, but still we see respondents a bit skeptical. It's still debatable. Member states are not sure. The attorney generals will always go and dispute on the jurisdiction. I should acknowledge I've lost a bit of track on the current cases, but the ones that I know, there is no, former registrar would be a good witness for me. There is no a single case where attorney generals and solicitor generals would not dispute on the jurisdiction. Do we do it in the local court? We do, but not often. At times, if a case is straightforward, we do not dispute. So for me, problem number one, I think the issue of jurisdiction is still debatable from day one. Why is it so? If you ask me, maybe is it because the court had jumped or was jumping to deal with human rights in early 2000s, the Katabazis case. And during that time, there were other courts, the SADC Tribunal and the ECOWAS Court, which had instrumentally ruled on human rights. Would maybe the court, the EACJ, wanted to jump and to go along with those other courts? And we should also be mindful that the African court also has not covered itself to the African member states to deal with human rights. So I would understand by that time, East African court wanted to grab the opportunity. But I think that is where the problem started. Article 27 with the proviso 27 sub 2 was never be clear, was set by member state purposely. I think I would tell on the, probably drafters will tell me during the negotiation, more probably that proviso was a reaching point. Two parties were agreeing and disagreeing on the jurisdiction. So I'm trying to cement on the issue that our court, our Jumuiya court, now, I think the issue of jurisdiction is a problem, jurisdiction on human rights. And this has, in a way, I've written a piece of paper on that. This has, in a way, affected big time legitimacy of the East African Court of Justice. So by affecting the legitimacy of the East African Court of Justice, it has bearing on the how now national courts adheres to the decision of the East African Court of Justice. Not only the national court, you have the Secretary General of the East African Community, you have the member states, you have the Council of Ministers, you have the summit. In a way, they have affected the legitimacy of the East African Court of Justice. So what is the cause? I would say the issue of jurisdiction. The issue of jurisdiction in relation to human rights, rule of law. Whether we like it or not, that is, to me, the centerpiece of debates along the East African Court of Justice. So, what to do? What to do, to me, is the question. Oh, first of all, what am I saying? I'm saying I see hello?
Dr. Posey, are you still there? We lost you for a moment.
So, hello, I'm back. Can you hear me?
Yes, we can hear you. Thank you.
Yes, so I'm seeing a challenge for the domestic courts, for the East African Court of Justice itself to have legitimacy, but also I'm seeing a challenge for the court to be given that respect it should have. So another challenge which we should also focus, I mean, now I'm trying to be real, not part of the government. We have a number of countries which have been added to the East African community. Does the court really give that representation to those members? In as far as culture of litigation, culture of the courts giving decisions, I think also EAC organs have to catch up with the changes that we are making within the court itself. But also another thing which we should also ask ourselves, this is not only on the East African Court of Justice, but we should ask as international lawyers, we should ask ourselves, where is international law going? You have, and this is also, the problem is at the United Nations, you have a veto, always a veto, only because this resolution, UN resolution, is not favored by Russia. And only maybe because the resolution has been submitted by the United States. You also have vice versa. You only have a veto or a resolution not being accepted by a big power, only because a rival country has issued a resolution. So we have to ask ourselves, where do we go with international law? I think this is the problem. International law, if you tell me international law is sinking, we see the issues of, for example, Ukraine, the issue of Gaza, countries are defying international resolutions. And this is bad for customary international law, because now Kenya and Tanzania one day, or Uganda, will defy international law and nobody will do it because we'll make reference to Ukraine. This also adds to the complications and challenges on like it increases the culture of not accepting international law. So that is the addition. For now, I would like to pause on that and we can continue with further discussion.
Thank you so much, Dr. for your contribution. And thank you for raising your concerns in terms of the legitimacy of the jurisdiction of the court, as well as the challenge that you see with regard to the domestic court's jurisdiction. Perhaps to continue with the same discussion, we are joined by Professor Chidi Odinkalu. Professor Chidi is a professor of practice in international human rights law at the Fletcher School of Law and currently chairs the Truth, Justice and Peace Commission, focusing on Southeast Nigeria. He chaired Nigeria's National Human Rights Commission and served on the panel of eminent persons that negotiated the return of the Gambia to the Commonwealth in 2017. He has acted as counsel before the African Regional Human Rights Courts and Tribunals and was involved in the creation of the African Court on Human and People's Rights. He researches contemporary challenges on multilateralism in regional systems in development, human rights, and governance. He holds a PhD from London School of Economics and Political Science. Welcome, Dr. Chidi, Professor Chidi, sorry for that. Perhaps, Professor, to take this up from where Dr. Ali Pozi left, do you see any challenge with the EACJ's jurisdiction? Does it, perhaps, has it been a problem in the ECOWAS region or any other region based on your experience under regional integration in Africa?
Thank you, Emily. Good morning, colleagues, and thank you for having me on this. And I'm glad that we're having this in a comparative context. But I think our comparative context should not just be geopolitical, reflecting the different the geographies of Africa's strengths. I also think we need to reflect on generations, the history of regional integration on the continent. And it seems to me, in the context of East Africa, in particular, sometimes some of our states are coming to the moment with the mentality of the East African Court of Appeal, the defunct East African Court of Appeal. And so that our approach to regional integration at the moment appears to be to eat our cake and to have it. Because regional integration assumes a sublimation to some extent at the minimum of sovereignty as we understand it. And the tendency appears to be that on the one hand, we accede to regional integration arrangement. On the other hand, we're unwilling to appreciate the implications of acceding to a regional integration arrangement. And the implications are fairly clear with reference to what it entails. And that's why the approach, broadly speaking, of first of all, the regional integration courts are courts of justice. And for the most part, therefore, questions of exertion of domestic remedies, which are at the heart of what very much we're talking about, the doctrinal tendency of lawyers to think, well, before you go to these places outside our shores, we've got to exercise our jurisdiction first. And in any case, if you're coming back to our shores with these decisions, we are at liberty to pick and choose, or indeed to disregard at all anything that you're bringing back. This is the foundation of that, and that's the challenge with the regional integration arrangements. And you find in that one or two things. First of all, the countries are perfunctory or compromised in the kinds of candidates that they send out to the regional integration courts, because those are not supposed to be courts that they take seriously. And secondly, the decisions of those courts, they find some ways to avoid. And one of them is by saying regional integration courts are not supposed to pronounce on decisions decisions that have been taken by national courts. The East African Court of Justice addressed that in EACJ against Burundi, which was the case arising from, I believe, Nkurunziza's attempt at getting a third term in 2015 or 2016. Because to do that, he had to set aside the Arusha Agreement, which was indeed negotiated by presidents of the East African Community. And having done that, he then got the Constitutional Court of Burundi to affirm him as entitled to run for a third term. And when that was challenged by the East African East African NGO Forum, he argued, or it was argued by the Attorney General of Burundi on his behalf, that the East African Court of Justice did not have jurisdiction over decisions of the East African, of the Burundi Constitutional Court. The first instance chamber certainly agreed with them, but the appellate chamber overruled and said there was jurisdiction because the Constitutional Court of Burundi is part of government. Government comprises three arms: executive, legislature, and the judiciary. And if the decision of any of the arms, including the judiciary, is incompatible with the rule of law obligations under the East African Community Treaty, then of course the jurisdiction of the Community Court is engaged. That issue has been, was problematic in ECOWAS. The ECOWAS Court of Justice has been there since 2001 actively, and 5-6 years after the ECOWAS Court of Justice began, the government of the Gambia, under the late Yahya Jammeh, decided that ECOWAS was being intrusive because the ECOWAS Court of Justice was being intrusive, challenging his dictatorial and authoritarian bent, and wanted to amend the Court of Justice protocol, the supplementary protocol on the ECOWAS Court of Justice, so that they would interpose a mandatory rule on exertion of domestic remedies. That was seen off by a combination of Nigeria, Liberia, and Senegal, which said basically what he was doing was he wanted to write into the ECOWAS rules a protection for his authoritarian bent. We are seeing a return to that now, not from dictators or in the ECOWAS region, but from national chief justices who are feeling affronted by the exercise of jurisdiction or assertion of jurisdiction in terms of community standards by the Court of Justice. They basically feel that they are lords of the manor or mistresses of the manor, of the judicial manors in their respective countries, and therefore that these courts of justice, whatever they're supposed to be somewhere out in the stakes, which are not supposed to be under their control, should be brought under their control. This is about egos. This is about personal egos and about judicial manners. And I do think that as citizens, we've got to ask ourselves the question, is this the kind of continent we want to live in which people find mechanisms for avoiding supervision and avoiding obligations that our countries have voluntarily entered into? These are not colonial arrangements. If we don't want them, we scrap them. But if we want them, can we at least as citizens stop inventing and supporting doctrines that simply undermine the effectiveness of the spaces that we have created for ourselves as Africans in order not to be criminalized? I yield at the moment.
Thank you so much, Professor Chidi, for your rich discussion. Perhaps the attendees, as we await your questions, you can use Q&A to, if you have any questions and you would wish any of the panelists to address. In the meantime, let me start with our panelist, Honorable Kubo, His Worship Honorable Kubo. Mheshimiwa, are you here with us? I hope you can hear me.
Yes, I am. I can hear you.
Thank you. You've listened to the sentiments of Dr. Posey and other panelists who spoke after you. Could you kindly explain the extent to which the EACJ's judicial review is done? What is the extent of the EACJ's powers in terms of reviewing municipal courts' decisions?
Thank you. I think EACJ's powers are limited in that even though you are reviewing decisions of a municipal courts, they cannot overturn that decision then, because that then becomes an appeal. They review the decisions to find out if it is in compliance with the treaty. If it is not compliant with the treaty, they say as much. Yes, you did your thing, you made your decisions, but you violated the treaty in doing so, which is wrong. In the future, make sure as you do your decisions, you comply with the treaty. Other than that, I don't think I've seen any other decision of EACJ that goes ahead to change a decision of municipal court. I have not seen. It is as short, it is as brief as that. It is like a review tribunal or an administrative tribunal of the municipal courts. What I said first, who will watch the watchers? It is watching municipal courts adherence to the provisions of the treaty, that in their work, they are free to do their work. Let them do as they do, but let them not violate the treaty at the same time. That is my take. Thank you.
Thank you, His Worship. That the EACJ's role is just to watch compliance with the treaty. I see we are joined with Council Everada. Council, you had a question? Council Evans Ogada, I saw you raise up your hand.
Good afternoon, my good friend Emily.
Good afternoon to you.
Can you hear me?
Yes, I can hear you very well.
Thank you. I'm following the good conversation with the speakers here. And my contribution is simply this, that when you look at the treaty and the treaty being an item of international law, we are in chaos in terms of the East Africa Court of Justice. For this reason, that when you want to have a conversation around international law, there are settled parameters for examining international law. For example, you have to look at Article 38 of the Statute of the ICJ. In terms of interpretation of international law, you have to look at Article 31 and 32 of the Vienna Convention on the Law of Treaties. That's where you start. What I see happening increasingly at the East African Court of Justice is chaotic. And this is informed particularly by how we choose our judges. We don't have uniform requirements for choosing of judges. We take people there who ought not to be there. That's a concern. Another problem with the court is operating as if it is a municipal court. If you read a good number of our judgments, you will find a reference to domestic law, which is a faux pas. It's a mistake that we still have to use Commonwealth and the precedent system in the Commonwealth when we have the treaty as the primary document for interpretation. I had Honorable Ali Posi state the problems with jurisdiction. I partly agree with him, but this is the question that I would want him to probably think about. In terms of Article 25, is it 25 or 27? 27 on the human rights jurisdiction. We don't have a human rights statute presently, but in terms of canons of interpretation, in terms of international law, we have the principle of pacta do contrahendo, pacta do negotiando. I have not seen this dealt with by the East African Court of Justice. So how do we bring back the international law nature of the EAC Treaty without doing the mess that we are doing currently and turning the court into a domestic law? Because the court is not an appellate court. It ought to deal with the treaty according to the rules of international law. Thank you very much.
Thank you so much, Councillor Gada. I don't know whether any of the panelists would wish to address the concern Council has as to how then the court should deal or focus on only the treaty and avoid matters to do with domestic perspective. Dr. Ali Posi, would you wish to start us off before I can invite His Worship Honorable Kubo to say something on this, because he has expertise based on this court and he would wish also to share his experience. Dr. Ali Posi. As we wait for Dr. Posi, His Worship, would you want to say something on what?
Yes, I can comment on what Evans Ogada has said. I fully agree with his sentiments about the courts not delving more into international law and creating its own jurisprudence around the treaty. But again, that goes back to what you said about who are the judges sitting there. And if Ogada will take the trouble to look at the decisions of the previous bench, headed by Justice Ogaraja Shebuja, now the Attorney General of Rwanda, I think that's the best bench I've ever had at EACJ. They were well grounded in international law and their decisions covered a lot in international law. But as you say, the benchmark for appointing judges to that court is not uniform. Whereas the treaty says anybody who is qualified to be appointed as a judge in his national country can be appointed at the EACJ. Do the country's partner states themselves have uniform requirements for one to be a judge? The answer is no. So you'll find you get a judge from one partner state with all the credentials, highly learned, and then you get him sitting with another judge from another partner state, you just don't know what to say. That to me is a problem that needs to be addressed at the highest level possible. If we can look into that, then we can make this court really come out with very good interpretations of jurisprudence on international law touching on the treaty. Thank you.
Thank you so much. Dr. Nalule, would you wish to add your voice on this issue?
Yeah, thank you for that. Let me just go back a bit to comment on the issue of jurisdiction that Dr. Aliposi raised. And for me, I see no problem with objections to or challenges to jurisdiction being made, because all international courts face that challenge. And I think it's also an opportunity for the court to kind of like carve out its own lay kind of like the law on what it is that comes within jurisdiction or what does not. So for me, I don't see, of course, it's also a lazy lawyer's crutch, kind of a way that, oh, I don't know what to argue on the merits, let me first argue on jurisdiction. So that too is there, but I think it's not problematic. In any case, it kind of like boosts, to me, it boosts the court's own jurisprudence regarding its jurisdiction. But then also on the issue that he raised on the backsliding in international law, and I think also Professor Chidi touched on it, I think it's all the more reason that we need the courts, yeah? And we see that the East African Court of Justice and perhaps even all African courts are in a unique position, since they are being strongly supported by the public and CSOs. If you look at who is taking the cases to these courts, it's mainly individuals and not mainly states against each other or institutions of the communities that they represent against the state. So it's mainly individuals that are driving and supporting these courts. So for me, this backsliding in international law is the more reason that we should support the court and kind of like continue making it and challenging it to make its stamp on its jurisdiction. So regarding the issue of choice of judges, I think it's one thing with our courts is that they are also under-resourced as such. For example, if you look at the Court of Justice of the European Union, it has a different setup. It has institutions like advocates general, it has researchers and so on that help. I don't know how well-resourced our own judges within the East African Court of Justice are kind of like equipped. And also, much as the judges may not meet the kind of like, some of them may fall short of the profile that we do expect of them. But also at times it depends on the lawyers who are coming before the judges themselves. Are they that well grounded to make those arguments and force the judges to kind of like address those very arguments on international law? Or for me, it's kind of like a two-way thing. It's yes, the courts themselves, but even us who are going before the courts, because at times it's the arguments, the strong arguments that the lawyers make that need to kind of like force the court to address this. But of course, the issue of choice of judges, I'm not kind of like in a way kind of like ignoring it, neglecting it, or it also needs to be addressed, but also all these others, the resources, and then the lawyers that are going before the courts. And also we have to remember that we are in a kind of like, I think it's what also Professor Dinkalu did raise, that we are kind of like in a look at the states, our states, we are not really that democratic, we do have a deficit in democracy. So the judges also have to be in a way kind of like, cautious and clever in the way that they do navigate that, especially given the experience of the backlash that they have experienced. So I'm not saying that they shouldn't do their work, but at times you can see it in their judgments that they are hesitant to make some very strong pronouncements and all that. But also it's like, how do we kind of like do help this institution so that it's not kind of like undermined by the very institutions that did set it up, or the very boards that set it up. So yeah, that's all I wanted to say for that time being.
Thank you, Dr. Nalule.
Can I just say one or two things, if possible?
Yes, Professor Chidi.
First of all, I think all of this argues for having an articulate domestic constituency in our respective countries for rule of law to begin with, and for the regional integration systems even more. And just to follow on from where Dr. Nalule stopped, in terms of resourcing of our courts, it's not just material resourcing, it is political resourcing. And the political resourcing of our courts is very poor indeed, of our judicial systems, as a matter of fact. We're talking here now about regional integration courts or regional courts of justice. The reality is that our judicial systems around the continent, bar none, from Cape to Cairo, as a matter of fact, at the moment, because even if you were, those who took these things for granted in South Africa can no longer do so. All of our courts are in trouble. Okay, you'll struggle to find countries on the continent where decisions of courts are respected, and you struggle indeed to find court systems also where judges are not under pressure for all manner of things, some of which they are responsible for, issues as in judicial corruption and the metastasis around that, to take an example. And so there are issues that we've also got to address. It's not as if the regional courts and tribunals are suffering from a pathology that is not afflicting other our domestic court systems, as a matter of fact. Now, that said, the political salience of some of the issues that kind of bubble up to the regional courts of justice invariably makes those courts fairly, fair targets in many ways of political jousting by different sovereigns amongst different countries, and sometimes entailing citizens now saying, well, to use an expression that is popular amongst French-speaking countries, on our souverain, we're sovereign. You're not supposed to get into our sovereign space. But really, it is because you're sovereign that these courts exist. It is because we're sovereign that we've created these courts. And it is because we are sovereign that we've empowered these courts to do the things they do, or they're supposed to do. A part of which is interpret the scope of their jurisdiction, as Dr. Nalule has, kindly enlightened us about. Now, so that really is the challenge here. Are we going to allow these courts to do what they are established to do? And part of that is taking evidence as to national law. It's not as if regional courts of justice should not be pronouncing on national law as a matter of international law doctrine. It is that national law before an international tribunal is a question of fact that should be established by evidence. Okay? So let's also be clear about some of the propositions we are bringing to the table here. There is nothing that says national law should not be pronounced upon by an international tribunal. It depends on the facts of each particular case and the evidence before the court. That is what the rules say. But I do think that we need to be careful to cultivate a domestic constituency in our respective countries and a regional constituency in our respective regions that makes it possible to reinforce the work that these courts are supposed to do. Otherwise, regional integration fails in Africa, and we go back to our little statelets created by the white people.
Thank you so much, Professor Chidi, for your take on this subject. There's a question that has been posed by Professor Mille, Tumash Mille. He's asking whether having East Africa Kiswahili, we have East Africa Kiswahili Commission, but we do not have an East Africa Judicial Service Commission. Is that a problem that is escalating the issue of the jurisdiction of the EACJ to review municipal courts' decisions? Dear panelists, any of you can answer that. Perhaps I can start with Professor Posey. He has not been able to participate in the previous conversation. Professor Dr. Posey, would you want to say something?
Oh, yes. With regards to whether we need Judicial Service Commission, my view is that, like I've said initially, we have now, even we should also ask ourselves from today, we have systemic problems or challenges with international law, not only on East African setting. So we might have Judicial Service Commission, we might have a beauty of provisions within the treaty, but I think we are developing a problem on the respect and acceptance of international law. And if you look at the EAC Treaty itself, it's not as bad as it looks on the challenges that we are having. As a matter of fact, we have a provision in the treaty that gives procedures on how to enforce a domestic decision. And I think Uganda, Kenya have tried it. Probably our advocates have not tried it. So I think it goes with even what my colleagues have said. It's a culture, a legal culture, which we develop under international law. I think that is the challenge. So what will the Judicial Service Commission do? I think it will cure the problem of domestic or national chief justices who feel that these international courts are overtaking their supremacy at the domestic level. So if that commission probably is well set, it involves regional CJs, and they, in a way, it makes them to have a common culture, judicial culture, common international law culture. I think in a way it will help to some extent to improve. I would put it to improve, because there is the political aspect, but in as far as the judicial aspect, it will improve how now judges or CJs view the regional court. Thank you.
Thank you, Daktari. I see His Worship want to say something. Please go ahead.
Yes, I was on that same question. You see, East African Kiswahili Commission was set up to advance the use and knowledge of Kiswahili in East Africa, which we have seen doing very well. Uganda now is teaching Kiswahili in all the schools. Now, the debate on the EAC Judicial Service Commission, I've had it very many times. One wonders, is it because this is a judicial body that touches on the rule of law that we want that at the regional level, or what? Because one will also ask, what about the members of parliament, EALA? Might we also need then East African Parliamentary Parliamentary Service Commission? What about the other staff of the community? Do we need East African Public Service Commission, so that all the employees of the community then have a commission that deals with its recruitment? I don't know, it's debatable. And I don't know if we have it in any other region. All these other regions, including the EU court, I don't know if we have a commission that deals with the appointment of judges to the regional court. It is something anyway that can be explored, but to me it is still very, very debatable whether we need it or not. That's my take.
Dr. Nalule, thank you, His Worship. Dr. Nalule, would you want to say something on this?
Yeah, it's something that I've never really considered, but I am thinking is going back to the national level of our different states that make up the EAC. How are our own judicial service commissions working? Are we happy with them, or are we going to be transferring problems, national problems, at the regional level? So that is the one thing I am thinking is we can come up with it. And of course, it would also need a treaty amendment to come up with that, because right now the power is vested in the partner states. Or is it something to say that we have the national judicial service commissions kind of like nominate the persons that should serve on the East African Community Court of Justice? That is what is going kind of like through my head. It's not something I have thought through completely, but those are issues that we should kind of like be thinking about.
Thank you so much for
just one note, moderator. The Caribbean Court of Justice had the Judicial Service Commission, and probably as His Worship was saying, the debate on the commission, I think at one point there was an attempt to have a treaty amendment. I think it was around 2010, 11. But it has disappeared. So probably we should not only look at the role of commission to it should not only be seen as to appoint or remove judges. Probably let us see it as a way to bring together the CJs, which is very important for these countries, in a way to bring that common culture of, because now you have all of them being in one umbrella. Probably they will be meeting regularly. In a way, it will be like an advocacy means. So we should look at it also on that way.
Thank you. Professor Chidi would want to say something on this subject.
Just to introduce quickly what happens at the ECOWAS level at the moment is that there is an ECOWAS Judicial Council. I mean, the prerogative on the nomination and election of judges at ECOWAS belongs to the respective countries, and I think Honorable Kubo pretty much described what happens, which is each country decides whom it nominates in accordance with the standards of the treaty. However, now for the past 6 years or thereabouts, there's now an ECOWAS Judicial Council, which comprises the chief justices of each of the ECOWAS member states. It doesn't recommend candidates for election. However, they're entitled to make comments. They'll see the slate of candidates. They can make comments on those. Ultimately, the states decide, as in the accredited representatives of the states decide, not the ECOWAS Judicial Council. They can take account of what the ECOWAS Judicial Council says. In reality, however, the ECOWAS Judicial Council does exercise quite considerable influence on the process, and national chief justices do see the candidates that are nominated pretty much. And they only allow for those whom they know will not challenge their respective domestic prerogatives and egos to get there, if I may add. Thank you.
Thank you so much for that contribution. We will open up the Q&A section. I would like to invite my colleague, Mr. Harrison Mburi, to take us through the Q&A. Dr. Mburi.
Thank you very much, Emily, and thank you so much to the panelists. My role is quite simple, is to try and pick up some of the questions that have been raised in the Q&A, and especially from our audience. The first one that I can see and we can engage with is the question of from Wandia Kinaro, which is, are there any repercussions to partner states if they don't act on EACJ judgments? I mean, I think this is a question of compliance. I think Honorable Kubo could possibly attempt that. Then Donna Award has a question to Honorable Dr. Ali Posse, who stated in his opening remarks, giving the challenges of the EACJ. So what are the suggestions Donna is asking on measures which can be taken to ensure that the jurisdiction of the EACJ is clear to member states? I think maybe that Dr. Posse can attempt that. And then the other one is and this goes to all the panelists think about having an enforcement body or an enforcement mechanism for dealing with decisions of the mechanism for decisions of the court to ensure compliance. I guess this goes back to the question of compliance, which has come back. I think that means that Honorable Kubo has one question, Dr. Ali Posse has one question. I want to ask one to Professor Chidi Odinkalu about this issue you raised on exhaustion of domestic or local remedies. It seems as if it's a bad thing generally on these regional courts, maybe knowing why might be important, because when Evans Ogada asked his question, he said, we should be behaving as much as possible as international courts. And many international courts think that exhaustion of local remedies is important. At least the African Court on Human People's Rights and the African Commission take the exhaustion of local remedies as an important aspect. Why wouldn't this be an important aspect for this court? And then for Dr. Nalule, I think the choice of judges was mentioned and we discussed this, and I think the contribution by Professor Dinkalu about this, financial resourcing and political resourcing was important. But there's something that Dr. Posi mentioned that we all must think about, at least for the EACJ, and maybe you can possibly comment on it. And that's the question of the challenge of new membership. Should they now the court has started a rotational system. So yes, there's a question of the choice of judges themselves, but as we stand now, there is a procedural challenge with the increase of members, and soon these questions will come up. Should we just have a rotational system, or should we increase the number of seats as had been previously when there were only 5 members, so that there was 10 in the first instance, and then 5 at the appellate division, or what should actually be the mechanism, noting the political and the financial resourcing challenges that you had mentioned. So I think I would now just then open this up to the panelists to try and engage with some of these questions. We will start again with Honorable Kubo, then we go to Honorable Dr. Ali Posi, then Dr. Nalule, and then Professor Dinkalu will conclude. So you have the floor, Honorable Kubo.
Thank you, Mbori. On the issue of whether there are repercussions, whether if a partner state does not act on a judgment of EACJ, that can be found in Article 38.2, where it says every partner state must take every step to implement a decision of the court. Of course, some of them don't. And what are the repercussions? We saw this in the decision, I think it was the case of Godfrey Magezi, where Godfrey Magezi was awarded costs, where Uganda government was supposed to pay him. Uganda government did not pay him. So he invoked Article 38.2 and sued Uganda again for violating the treaty. So it sort of now becomes a vicious circle. Okay, you have sued them again for violating treaty by refusing to act immediately, implement a decision of the courts. He got judgment. Fortunately, now they paid. So it stopped there. But I was looking at a situation that had they not paid, again, we have sued and sued and sued and sued and sued. Something needs to be done. And of course, the issues of execution come in, that you cannot execute even at national level. You don't just execute against the government. So yes, there is something that can be done. You can be cited for violating the treaty again if you don't obey the decision of the courts. Maybe also touch on the exhaustion of local remedies, where the EACJ is a bit unique in that area. If you go to COMESA, you'll find you must exhaust local remedies. But this issue of not exhausting local remedies under EACJ can be traced to Article 7 of the treaty, which it talks about people-centered and market-driven. So where it is people-centered, and then you are telling this person that you have to wait until you exhaust all the local remedies, by the time he gets to the final court, maybe Supreme Court, those will be so many years, it will have been so expensive, he may not even have that energy again to go to EACJ, and then link that with the limitation of 60 days from the date that happened. So if you want to be within the limitation period, there's no way you are going to go through the local remedies to complete that. Otherwise, the provision should have been reading 60 days after exhaustion of local remedies, which was going to be so expensive, and then it will not be people-friendly as far as the community was concerned. And those are the people who are enjoying the benefits of the community. The number of judges, this has again been an issue of discussion in very, very many discourse. Appellate 5, first instance 10. If you ask me, I'll tell you those appellate 5 are enough, even if we have 20 member states, because first of all, not every case goes on appeal. And the other time I had a debate with the judges, they was telling me I should give them equal number of days I give first instance division. And I was saying, no, I'll give you your sessions according to your workload. because we are talking about resources. And I asked them, if the first instance were to do their work so well that everybody is happy and nobody files an appeal and there's no appeal in the appellate, why should I bring you? What will you be coming to do? There'll be no work for you. So to me, because not every case goes on appeal, those 5 to me are enough. The problem is how to rotate it, which country will be having 2 judges and which country will be having 1 judge. Because as it is now, there's some countries that have only 1 judge and others have 2. In fact, I know a country like South Sudan, where there was an opportunity to propose an amendment to the treaty. All they wanted was to amend the treaty for them to have a judge in the appellate division, which of course was going to increase the costs. That again goes with the too many memberships we are now having. Who is now knocking on the door? Ethiopia is knocking at the door. We don't know whether they'll come in soon or not. We have sort of moved more into widening than a deepening. So if all of them come in and all of them have to appoint a judge, we are soon going to have 10 or 9 judges in the first instance division. Maximum is 10. Even if another member comes in and we have 10 in the first instance, to me, I think those are just enough. With the 10 judges in the first instance division, we can have 2 panels sitting at the same time, 5-5. Then the ones that go to appeal, they'll meet the 5 there, and that is just enough. Remember, partner states are the very people who have been saying how running the community is so expensive, resources are not enough. But again, they are the very people who keep admitting more members, and immediately some of those members are admitted, they appoint people to those positions, and then they don't pay contributions. What happens? It's a whole mix-up. The whole thing needs to be relooked. The whole thing needs to be overlooked, overhauled and be relooked without any biasness, so that we come up with a proper structure of how the community and the courts can work. Thank you. I think mine, I'll comment on those only.
Thank you so much, Honorable Kubo. And I think you've raised very many interesting issues. I think some that Dr. Honorable Ali Posi can possibly also, chime in on and tell us what his view is. I think, Dr. Posi, maybe before you begin, there's this thing you mentioned that I thought was very interesting, this culture of litigation. Now we have members who are coming up with different cultures of litigation, including from different, ways of doing things, including language. And we've spoken about Kiswahili. Maybe you can also mention this in your comments. Thanks.
Thank you. I'll quickly pick a number of issues randomly. The first issue, how do we, what happens if a member state does not comply? What does the treaty say? His worship had stated, but also the treaty allows issues of sanctions. International law operates under sanctions, which is also a challenge among African countries who we all know we work under brotherly diplomatic relationships. So there is a challenge on that. So if a country does not comply, then we might run into difficulties in making sure that there is compliance. And then the issue of exhaustion of domestic remedy, the EACJ, as we all know, is not set up for that. Not like the protocol to the African Charter on the establishment of the African Court on Human and People's Rights. But I still believe exhaustion of domestic remedy is important because of the Tanzanian experience. If you are not careful, if litigants floods international court, there is where it becomes a problem with politics and the domestic judiciary. In Tanzania, we withdrew individual access, the declaration that individuals can directly access the African Court. Of course, the direct access of the African Court is different from the EACJ. But what happened is that we are having a flood of cases to the African Court with regards to the fair trial. So even though African Court had exhaustion of domestic remedy rule, And again, still the flooding happened, and then still a nation wants to withdraw its individual access. I remember when we were doing research, we also thought that these courts having direct access might also have or might pose danger for the regional court to enter into a political wrangle with a member state. So I think exhaustion of domestic remedy is important. You give a country an opportunity to rule on it. Probably we should set our rules, our procedural rules, more friendly for litigants on that. What are the challenges on the issue of jurisdiction of the East African Court? What do we do? How do we move forward? I think we need to be clear. Do we want human rights jurisdiction or not? That debate was there since the inception of the court. That ambiguity was there. Everyone who wrote on or researched on the East African Court of Justice, the conundrum was the issue of human rights jurisdiction. So we need to set up, if we do not want human rights jurisdiction, fine, let's go with it. But at the end of the day, what is the future of the court? SADC tribunal abandoned even individual access. So we should not be scared to call for discussions, research, assessment, review on the court or EACJ's mandate. We should not be scared. I think that is the way forward. We should really sit down, unpack everything, assess everything, and then we clearly give mandate to the court. Can it have human rights jurisdiction? Yes, it can. The ECOWAS court has it, and I think it's doing quite okay in as far as our standards are concerned. So it can still have it, even without having a human rights charter, because the provisions also refer to the other international instruments, including the African Charter on Human and People's Rights. You said the issue of difference in litigation culture. It is also something that we must look, because we as His Worship was saying, we are actually spreading that rather than deepening. So when we are spreading, we invite different cultures. We have to look at it now, where we are going. Concerning the number of judges, I think they are enough, really. 5 is enough. Appellate division, first instance division, it's enough. By the way, even the question of having an appellate division is questionable. We all know the Anyongo saga to do that. Of course, it's also debatable to some of us scholars whether a regional court should have an appellate division or not. But of course, for me, with the EACJ having a direct access, it is always better to have an appellate division. So different cultures in litigation, I think, yeah, we have to unpack everything. I think that is what I could say for those issues.
Thank you so much, Dr. Honorable Ali Posi. I would now like to pass it over to Dr. Nalule on any of these concerns that you can possibly engage with. And then we will go to Professor Chidi Odinka.
Okay, just quickly, I think the previous speakers have kind of like adequately covered most of the questions, but just to chip in, to disagree to some of what they have said. Now, regarding the challenge of new membership, I think as Honorable Okubo said, we are quick to kind of like add on to members and not thinking through the implications of that, yeah? Because I don't think it's only the EACJ that is having to face challenges of resources, yeah? What happens when you have more members? I think also there are other organs and institutions of the EAC that are having similar questions or raising similar questions. So I think it's a matter for the EAC leadership. I mean, spearheaded probably by the questions the Secretary General should put to the summit or the Council of Ministers, and they kind of like see where do we need to amend the treaty to kind of like accommodate this, given the resources and the experience we have in this area. So that is the question that needs to be asked. Then secondly, regarding the exhaustion of local remedies, that is not built into the treaty. The treaty wasn't meant to be kind of like a human rights treaty or the human rights bodies on the continent. Because first of all, recall that this one has a specific jurisdiction to kind of like interpret and apply the treaty, the EAC Treaty, yeah? And compared to, say, human rights bodies, for them, they are dealing with issues that could have been raised at the national level, and probably they are the same issues that would have been raised at the national level will be the same ones raised at the regional court. So here it's different. Here the EAC is looking at whether there have been violations of the treaty, infringement or violation of the treaty. So it may not be necessarily the same issue, although that it's based on the same facts, but it may not be the same issue that the court has to determine. So then the issue of exhaustion of judicial remedies may be kind of like, so it all goes back to the question of jurisdiction of the court, which I think we started with, but I don't think, and also because the reason this is coming up is because inadvertently, I think the court has ended up deciding more on rule of law cases and human rights law cases, which I think initially people didn't think would be kind of like their mainstay, so to speak. It would have been initially economic or trade-related cases, in which case, at times, this issue of exhaustion of local remedies may not necessarily have arisen, but because it's come up with mainly all these human rights and rule of law cases, that we are kind of like comparing it to the regional human rights courts, which is not, I don't think is, in many cases, there are cases where you cannot compare the two jurisdictions.
Okay, thank you very much, Dr. Nalule. I'll now move on to Professor Dinkalu on some of these issues. Just your views, you could possibly chime in also on other areas.
Well, thanks a lot, sir. Let me just let me address two things, I think. One is the question of legal cultures, and the other is the question relating to exhaustion of domestic remedies, much of which has already been dealt with by my predecessors on this particular slot of questions. Now, on the question of legal cultures, it seems to me that in the EAC in particular, you may wish to address the procedures for accession. Now, if you go back to when Rwanda and Burundi, when the expansion started beyond the three original partner states, and the accession of Rwanda and Burundi went through tremendous examination. The process was long drawn out following their applications to join. The process was very long drawn out, and there was a very rigorous audit of their domestic systems with indications of where improvements needed to be made before they could be allowed to accede. And that took a long time. That process has now been abandoned. That rigorous process of pre-accession audit in the EAC system has been abandoned. And instead, it looks to be an imperative to get the EAC, geopolitically speaking, as quickly as possible to the territory of the Gulf of Eden. And as a result, the processes that you actually need to go through of ensuring ultimate viability of convergence have been abandoned. That, in my view, is probably a prophylactic way of addressing this question of legal cultures, adaptability, or mutual compatibility and integration of legal cultures, which I believe is an important issue and a foreseeable issue that can easily be managed. Now, on the exhaustion of domestic remedies, I think Honorable Okubo and Dr. Nalule have addressed it. I just want to say two things. At the level of explaining this, we've got to understand that there are two dimensions. One is intrinsic and one is functional. a regional integration system is an integrated legal order. And as such, as Dr. Nalule said, cannot subject itself to the same imperatives of exhaustion of domestic remedies. But there is a functional reason for that. If you are take a customs union, okay? A country is a customs union. And so that means what? You clear goods at one customs point and you can transit from one point to the other. If the EAC is a customs union, why do you want to interpose exhaustion of domestic remedies in a customs union? It doesn't make sense. So if you go to Kenya and you clear your goods in Mombasa and you're litigating, you're then telling the person in Mombasa who has cleared goods, or say somebody in Nanyuki, to if you want to litigate about goods cleared in Mombasa, exhaust domestic remedies in Mombasa, that means you're balkanizing Kenya. It's the same thing. If East African Community is a customs territory, it means that if you clear goods in Mombasa, it's good for Kigali. If you're then telling the person in Kigali, exhaust domestic remedies in Mombasa before you get to Kigali, you have not made the mental transition as to what a customs union entails. So this is the problem I talked about, that we're bringing to regional integration a mindset that is out of date. We need to actually re-engineer and rewire our heads for purposes of legal supervision of a regional integration mechanism. The second issue is the Tanzania question raised by Mheshimiwa Ali Pose. And in my view, the narrative he presents is incomplete. Now, I was there when we negotiated the African Court Protocol, and the negotiation was very clear. There is an opt-in in the African Court Protocol. So acceding to the African Court Protocol is not enough. If you accede only to the African Court Protocol, your route to the court is through the African Commission on Human and People's Rights to exhaust domestic remedies. However, you can go to in addition to acceding to African Court Protocol, you can accede to Article 34.6, which gives direct access to the court only to the countries, to citizens or people suing against the countries that have done that. Tanzania chose to instrumentalize Article 34.6 because it wanted to host the court. Okay? So when Tanzania wanted to host the court, it went and, in addition to ratifying the African Court Protocol, it indicated acceptance of Article 34.6 and made itself open to direct supervision by the African Court. When the consequences then started coming through, they decided to pick and choose, and now they're complaining. That is instrumentalization of a regional court and tribunal, and that is what we don't want, because politicians domestically want to do precisely that, pick and choose what pleases them. And that is my problem with the example he gives of what happened to the SADC tribunal. The SADC tribunal, with reference to the removal of the right of individual access to the court, was a reprisal for the decision of the court in the Campbell case. Okay, and that was because it affected the issue of land reform or abuse of land reform by the Mugabe government in Zimbabwe. I don't think that's actually a good example for East Africa. If every time the court gives a decision, they're going to be clobbered, or countries are going to destroy the court or ransack it, then we would as well just sack the court and say we don't need regional court and tribunal in East Africa and start afresh. So I think we've got to be careful about the precedents we want to recommend for our regional courts and tribunals on the continent. Some of them are actually offensive, and some of them are not things that conduce to the kinds of systems that we're advocating for. I yield.
Thank you so much, Professor Dinkalu and all the panelists. I see our time is much spent. I'll just go to possibly one last round. There are a few questions here, might not possibly need for all of us to comment on. The first one is by Professor Thomas Milej from Kenyatta University. Thank you so much, Prof. Milej, for attending. We really appreciate your presence here. I know there are many other people who have set time from their busy schedules to attend. We have our dean at Kabarak Law School, Professor John Ambani. I see many faculty members from Kabarak Law School who are also present in this session. I see many friends, many students of Kabarak Law School and elsewhere, and all the other faculty members from other parts of East Africa and beyond. Thank you very much for joining us. We really appreciate your presence, and we want to say thank you for being part of this webinar. So for this question, I will go to the one that has been presented by Professor Milej, and he says this, that the EACJ is not an international court purely. It is also not a national one purely. It's an international integration court. I think some panelists have mentioned this. It's sui generis, as he describes it. So in this case, other international courts have power to review state actions on compatibility with internal rule of law. I think that's a statement. So the question is, we need to ask which other international courts of a sui generis nature have powers to review state actions on compatibility with internal law via the rule of law principle. I hope I'm doing justice to that question, Prof. Milej, and I would also love to hear what our panelists would say about it. Then Chep Korir, who's our editor here at Jumuiya, also has a question here. She asks, unlike other regs with courts, e.g. ECOWAS and EAC, e.g. ECOWAS, the EAC has a vision to transform into a federation, which is true. How does that make its jurisdiction different? Is that a factor having an implication on the jurisdiction and to the extent of its powers? So those are the two. I would say this is, for me, the final round of questioning. I'll also think that it might be a good opportunity for our panelists to chime in on these questions, possibly, and any other matter that they wanted to talk about. For example, Dr. Nalule wanted to speak briefly about compliance and repercussions. It might be a good opportunity to, if you have to answer these questions, but also to give some sort of closing remarks, in a sense, because after this, I don't know, and Emily will guide me. I don't think we will have enough time to come back again, because we only have less than 15 minutes to go. So I will take again another round like we have done before, from Honorable Kubo, then to Honorable Dr. Ali Posi, then to Dr. Nalule, and finally to Professor Odinkalu, and then I will hand it over to Emily so that we can go towards closing. Honorable Kubo, you have the floor.
Thank you. Let me just comment something small first of all about the consequences of not following the decision of the court, where Ali Posi said there are sanctions. Yes, the treaty talks about sanctions, but it doesn't mention which sanctions. In fact, it starts that paragraph by saying that if you don't meet your financial obligations and other obligations, you'll be subject to sanctions. We really debated what sanctions can be issued by the summit, but we never agreed. And I think that was deliberate, so that there are no sanctions against anybody, any partner state violating the treaty. And that's where it fails. Now, on Chep Korir's questions, whether transformation of EAC into a federation and how it will affect the jurisdiction of the court. Definitely, it will affect the jurisdiction of the courts. What we don't know is whether it will affect it positively or negatively. My fear is that it might affect it negatively, because I'm aware some attorney generals have not been happy completely with the decisions of the courts, and they are looking for a slightest opportunity to touch on the jurisdiction of the court where they will claw back. So we might have a federation with a court with the lesser jurisdiction that it may not be as effective as it is now. And I've been saying in other forums that I'd rather the jurisdiction of the court is not touched. You open it up a bit, you may be risking a lot. My good friend, Professor Milej, are really not clear about that question. Let me not touch it and give my colleagues an opportunity to dwell on it. Thank you.
Thank you, moderator. Professor Milej, whether let me try to rephrase it. Let me try to be clear on it, whether a regional or rec court, there is another rec court can interpret or apply national actions at the regional level. I think the ECOWAS does it. The expert from the ECOWAS court might have a say. On my writings, I also had a lot of reference with the Caribbean courts. It was almost a replica of the East African Court of Justice. And by the way, I think we should not forget also the art of litigation. If you look at Katabazi case, the court had already existed some few years, but the issue of how to now to squeeze the issue of human rights, if I'm to say so, was, I would argue, it was not that much appreciated by litigants. So litigants in the Katabazi case, for us scholars in the East African Court of Justice, we actually commend the litigants on introducing the issue of human rights litigation. So it went on up to the Democratic Party case, where even the appeal jurisdiction had directly said that we have jurisdiction to interpret and apply human rights matters. And that is why up today you see a number of cases, EAC judges are somehow confident in doing so. So I think there's an art of litigation in order of enabling the court to lead the court or to help the court to make a certain judgment. That is one. Also, there's the issue we spoke about. We scholars, we always say and commend the first batch of judges, East African scholars, East African Court of Justice scholars. We tend to commend the first batch of judges. We thought that they were more, I would say, more nurturing, trying to construct or trying to build the court's stature. So I think judges also have an impact on to what extent a regional economic community court can have a role in adjudicating matters in relating to the either community or even touching member states. Whether it is it it's not an international court or domestic court, I would strongly say it's an international court, as long as it's not up to the political federation, where we have one constitution of East African community. Still, I think regional community are governed by international treaty, and the East African Community Treaty is an typical international instrument. The second issue, kindly remind me, I did not hear well, moderator.
I actually think you've covered the two issues. The first one was on the federation, and the second was on the internal law.
Oh, the federation, whether we need
Yes.
we need to amend. Definitely, you cannot have a federation where you are not sure of your court's jurisdiction. That's why I think we need to unpack to be real on what we really want. And there's that danger, as Worship Okubo said, if you touch the jurisdiction of the court, as the other scholar had said, they will take you to the SADC tribunal, cut off individual access, make member states themselves litigating, where you have a dormant court, or you have experience like the Comesa court. I think they even have changed the seat. I think it was in Sudan or something. I don't remember. Or they took it to Lusaka. There were those debates where you make it more challenging for litigants to access it. So But again, we cannot avoid looking and unpacking the East African Court of Justice jurisdiction when we reach political federation. We cannot avoid it, so it's a must.
Okay, thank you very much. Dr. Nalule, you have the floor.
Thank you very much. First of all, just to comment briefly on the issue of the international court, I was like, okay, if it's not purely an international court, I kind of like got stuck there. Then why do you say it's not a purely international court and it's that sort of thing? What constitutes an international court? So I was kind of like taking the debate back to those basics, but that is a discussion for another day. What I would like to briefly say on the question that was raised, are the international courts to review state actions compatibility with internal law? I think we see that because when you say internal law at this point, you forget that the East African community law has become part of internal law. So it's the EACJ has jurisdiction to review the internal law via the East African Community Treaty that has become part of the internal law. So I think that is where you are seeing EAC Treaty as being international and not part of internal law, which is different. It is internal law over state. So that is what I'll say about that. And then on the issue of the political federation, I think the court is vital for pushing this objective of the political federation, because it is still an objective of the commission of the community. We are headed towards whether it happens in 20 years, 10 years, 50 years, whenever it happens, that is still the objective of the community. And I think the court is vital in pushing this objective through its legal and jurisprudential integration interventions. So we have seen that say also with the Court of Justice of European Union, which has been accused of putting a federation that is not even envisaged under their EU treaty, but for us, it is part of the EU treaty. So I think the court has a role to play there. And for me, I think at that point in time, as and when, or before it happens, when we know that this is the next stage and we're definitely headed there, I think the role of the court should be revised. But it's how is the revision being done? If it's for state parties, the summit and the Council of Ministers to sit and decide for the rest of us, then of course they will tamper with the jurisdiction of the court in a negative sense. But if it's a people-centered thing, we are all kind of like involved, it's done in a democratic sense, then I think we should, because the people have already demonstrated that they need the court. They are the ones that are using the court. And I think they have more to contribute on how they would like the court to address their needs. So for me, I think it's how it is done. That the court might be, but I think at the point of the federation, we need to have a discussion involving as wide as possible, wide consultations as possible. And then, yeah, the final thing, two final things on repercussions. I think we tend to forget that somewhere in the treaty there is the provision of suspension and suspension and what's the other one? Suspension of a member state or expulsion of a member state when they consistently violate the treaty. Of course, given the politics, member states may be reluctant to use that, but I think that is kind of like the ultimate repercussion for member states that violate or infringe the treaty: suspension or expulsion. And then finally, and this is a challenge to all gathered here, is that are we teaching EAC? We are talking integration here. We are talking about the courts, its challenges, its shortcomings, but its relation with national courts. But how are we in law school? Are we yet teaching East African community law as such? Yeah, because we are the ones that are kind of like meant to support and push for this kind of like integration. So if the students come out of law school, they know nothing about East African community law, and then they are starting to practice it, how are they going to raise challenges within national courts? How are those challenges going to go into that if they are not aware of the law that they're supposed to be implementing? So I think it's a challenge to all of us within the East African community. Go back to the law schools and have a clear course on East African community law, because I think it has developed so much at this point in time, 20 years, so 20 plus years since the community was established. So yeah, we need to have some serious courses, and then we can start talking of all these issues with kind of like, without four fingers pointing at us and then the one finger pointing at the court. Thank you.
Thank you so much. Prof. Odinkalu?
It's difficult to say anything after listening to Dr. Nalule, quite honestly. I think she summed things up so well, particularly the last point on which she ends, that about the need to teach East African community law. And I would actually go on and suggest comparative regional integration law in Africa. I mean, the pioneering piece of work on the old East African community, if I may say so, was actually done by a West African, Ositeze, in his PhD work, which was published ultimately on the East African Common Market in 1973. When I listened to this question about whether or not the EACJ is an international court, I kind of chuckle, because this is the mindset that put paid to the East African Court of Appeal. But there's no question that the question is actually arising now in 2024. Tells you all. So the blame is not with the politicians. It's actually with the people, with the intellectuals and law teachers who set doctrine in the law faculties. This court is created by treaty, endowed with jurisdiction under treaty, signed and acceded to by the countries of the region. And we're still asking whether or not it's an international court. That, I think, makes the point that Dr. Nalule makes. And there is an urgency, in my view, to doing that. And I've got to also congratulate the Kabarak University for having the journal. My hope is that it's not going to be just one issue per annum, but that it's going to be possible to do that at least on a biannual basis, have 2 issues of the journal annually. But even more, to open up the blog, so that it's not just Afronomics blog, which is run by exiles, African intellectual exiles from the United States. I do think we now need to have a blog that encourages conversation, cross-regional conversation across the continent, involving the various constituencies. And I'd like to hope that the Kabarak University can evince an ambition beyond just the East African community to covering all the other regional courts and tribunals, so that we don't have to keep going to South Africa, to the University of Pretoria, run out of Boer country, for Africans to begin to discuss about our continent. I don't look at Boer country as where we are going to get our liberation, intellectual liberation in Africa from, with all due, and I admire a lot what University of Pretoria is doing. My hope is that Kabarak University can begin to foster the kind of combustion, intellectual combustion we need. And that involves going beyond East Africa, taking on the East African challenge, but going beyond that to also include the remainder of the continent. Congratulations and thank you.
Thank you very much. I'll now hand over the floor to Emily for purposes of conclusion.
Thank you so much to the panelists. Thank you, Honorable Kubo, Honorable Alipozi, Dr. Nalule, and Professor Chidi for this insightful and rich conversation. Indeed, Professor Chidi has challenged us to take it further. We assure you that we will take that seriously. From my side, because of time, I have seen a number of attendees wanted to comment and ask questions. However, because of time, kindly allow us to stop here. Please allow us to appreciate all the attendees who have attended from the East African community and even beyond. Thank you for your time, and we hope that you shall join us. We will be organizing another webinar in May. We are also reminding you that we have the call for case commentaries and reviews. The deadline is on 30th of June. If you have any case commentary and review on East African community law, feel free to publish with us. We also have the blog. If you wish to publish anything, Professor Chidi, you can also share your articles beyond EAC. They will be rich for their blog. Thank you all for your contribution at this juncture. I would wish to invite our Mr. Mogesi to pray for us as we finish. And after that, please feel free to leave at your own pleasure.
Okay, let's pray. Our Father art in heaven, we glorify your name once again for the opportunity you've given us to have these wonderful discussions about regional integration in East Africa and beyond. And we ask that this doesn't end here, that we might continue having discussions that will impact our lives, citizens of the East Africa community and beyond again. In Jesus' name, I pray and believe. Amen.
Amen. Thank you so much. We are really humbled that you joined us. Please feel free to leave at your own pleasure. Thank you so much.
Thanks, guys.
Thank you,
you.
everyone, and
Thank
bye.
you. See you.
Asante
Thank you.
sana.
Thank you.
Asante, asante.